Well, good morning, everybody. Thank you for getting up on a beautiful Saturday morning here in South Bend. Welcome home to Notre Dame. And for those of you, I'm assuming some of you are visiting from San Diego because you brought us your weather, so thank you for that. The subject for this seminar is called What's Next for the Supreme Court? And I have to admit, when the alumni folks asked me to speak on this topic, I was a little nervous. Like the man once said, it's difficult to make predictions, especially about the future. And I actually know more about what the Supreme Court was doing in 1819 when it decided its most important case ever, McCulloch versus Maryland. And I know a fair bit about what the court was doing in 1919 when Oliver Wendell Holmes wrote some famous dissents in free speech cases and basically foretold what modern free speech law was going to look at. I feel pretty good in the distant past, but if you're asking me what's going to happen in the 2019-2020 term, I'm a little bit at a loss. And you might remember there was a guy on TV, Bill O'Reilly, who used to call academics pinheads. And I'm kind of a pinhead when it comes to being able to make predictions. Back in the fall of 2016, you can't imagine how confidently I was assuring every media person who asked me what was going to happen in the upcoming presidential election and what that would mean for the Supreme Court. And to put it mildly, I got it wrong. In fact, I was so wrong, despite my confidence, that I've decided to try a little trick, and I'm going to confidently predict right now that the Irish won't win the national championship this coming year. Right out of the gate, I'd like to put in a plug for a book written by my former boss, the late Chief Justice William Rehnquist, The Supreme Court, How It Was, How It Is. He wrote it when he was a relatively new justice back in the early 80s. And I'm mentioning this not because I get a plug or I get a cut of the royalties, but I mention it because I think it really is the most accessible, easy to read, fun to read account of the Supreme Court as an institution that you can find, even 30 years later. So if you're interested in learning more about the court and how it works and how it's worked over time, this is a great place to start. Another reason I mentioned this book, actually, I was reading about all the different classes that are back here for their reunions, and I was on a plane with a gentleman who was coming out for the 65th, which I thought was awesome. At the time when that gentleman was here at Notre Dame, Chief Justice Rehnquist was starting his clerkship for the famous Justice Robert Jackson. And the first case that Rehnquist writes about in this book is a case from that term, a really famous decision involving President Truman's effort to nationalize the steel mills during the Korean War. It's called Youngstown Sheet and Tube. And so Rehnquist frames and opens his book with a story of what it was like to be a law clerk for Justice Jackson during that term. And interestingly, the case was actually decided 67 years ago today, and it involved really delicate, novel questions of unilateral presidential power. And so we can see that some issues always stay relevant and timely. Well, what's next for the Supreme Court? I want to suggest that, in fact, despite what you learned in high school civics classes, or despite what you learned in your government or political science classes here at Notre Dame, and notwithstanding what Alexander Hamilton said in the Federalist Papers, and notwithstanding what Nina Totenberg tells us on NPR, there are actually two Supreme Courts. This might sound kind of crazy, but bear with me. First, there's what I call the May Court, and then there's the June Court. Now, the May Court is actually July through May. It's everything but June, but you get the idea. The June Court is the one that journalists fixate on. The June Court is the one that Senate confirmation hearings focus on, and that 95% of constitutional law professors obsess over. The June Court is the one that issues landmark rulings on controversial social questions and moral topics, decisions about race-based affirmative action, the regulation of abortion, the legal definition of marriage, the scope of the First Amendment's free speech guarantee, prayer in schools, and about the government's power to require the purchase of health insurance. This is the kind of stuff the June Court really digs into. The The Jun Court hands down lots of 5-4 party line decisions that reporters like to call sharply divided. And the Jun Court produces lots of dissents that the press tells us are fiery, scathing, and bitter. The Jun Court's opinions are criticized by candidates on the campaign trail and even by presidents during their State of the Union addresses. The Jun Court's work prompts campaign promises of packing the court or expanding its size, prompts dramas on HBO, and as we saw in 2016, it even inspires some candidates to provide upfront anticipatory lists of who they're going to put on it. So today, when primary candidates in the election are talking about packing the court, it's the Jun Court they're thinking about packing. Or when senators and judiciary committees proclaim themselves to be Spartacus or speculate about how loudly the dogma might be living within some people, it's the Jun Court they're thinking of. The Jun Court doesn't look much like what Alexander Hamilton famously called the least dangerous branch. Instead, critics would say, it seems to regard itself, in Judge Learned Hand's words, as a bevy of Platonic guardians. So things have changed since Hamilton wrote The Federalist, and for a variety of reasons, including the rights revolution of the 1960s and perhaps Congress's inability or unwillingness to legislate, the court's role in our country's politics and policies and culture and imagination has ballooned, for better or for worse. I'm going to suggest it's for worse. So every summer, in June, where we are now, as the court's term comes to an end, all of the high-profile, hot-button decisions are released and political junkies are glued to their computer screens and to the SCOTUS blog website, like my Marvel Comics universe fan daughter who's waiting for the new Avenger trailer to drop. Each new, much-anticipated 5-4 ruling prompts howls and hosannas, grim pronouncements that doom is near, or relieved assurances that we are saved, and confident assertions about the implications and the intrigues behind the opinion. So last year, the agitation was amped up to 11 due to Justice Anthony Kennedy's retirement announcement, and then President Trump's nomination after a somewhat reality TV-ish week of then Judge Brett Kavanaugh to replace him. But it's worth remembering, again, the Jun Court doesn't seem so much like the court that the nation's second Chief Justice, John Rutledge of South Carolina, quit after just a year and a half because he said it was too boring. He went back to be a trial judge in South Carolina because the Supreme Court had heard no cases during the year and a half that he was the Chief Justice. Now, I assume that actually, despite all of my trash talking of the Jun Court, that's probably what most of you have come to hear about. But if you'll indulge me, I want to say a few things about the May Court. The May Court, in my view, is the institution that the Constitution, got to carry one around, right? That the Constitution creates in Article 3. This is the institution of our national government that Hamilton said in the Federalist Papers would be the weakest of the three branches because, in his words, it had no influence over either the sword or the purse. It may truly be said, he continued, to have neither force nor will, but merely judgment. And he went on to quote the French political theorist Montesquieu, who had said that, quote, of the three powers, the judiciary is next to nothing. How things change. I want to tell you that the May Court, based on my experience, both working there as a law clerk way back when and observing it ever since, the May Court does its work efficiently, inexpensively, collegially, and well. The essential work of the entire federal judiciary, in fact, consumes just 1% of the federal budget. The May Court is housed in just one building, the construction of which actually came in under budget in 1935. The May Court's members are well-credentialed, careful, accomplished lawyers, skilled technicians who get along pretty well. On this court, Justice Scalia and Justice Ginsburg had a deep friendship and a shared love of opera. Justice O'Connor would win NCAA tournament pools. Justice Thurgood Marshall would admit that Justice William Rehnquist was his favorite justice. And Justices Breyer and Thomas would pass notes on the bench about football games. The May Court disposes of about 8,000 petitions a year in addition to overseeing the federal rules of procedure, and in the Chief Justice's case, serving as Chancellor to the Smithsonian Institution. Most of the cases the May Court decides are unanimous, or nearly so, and the disagreements on the May Court rarely track liberal, conservative, Republican, Democrat lines. So if I were a better law professor, I'd have a bunch of PowerPoint slides right now to show you, but I'm actually not a fan of PowerPoint slides, but I am going to give you some numbers. During the 2015 term, which if you remember, included some really contentious cases about abortion and affirmative action and so on, during that 2015 term, 48% of the court's rulings were unanimous and 80% were 7-2 or better. And this is consistent with the average over the last 7 years. Over the last 7 years, if you count 8-1 cases as being pretty much unanimous, they've agreed almost entirely 60% of the time. But that doesn't make for good fodder on the front pages or on talk radio. In 2017, the court's most liberal and most conservative members, and I'm using Justices Thomas and Ginsburg for this comparison, they still agreed 55% of the time. Last year, which was, as some of you might remember, among the court's most controversial and divisive terms in a long time, and included cases about religious freedom and gay rights and public employee union dues and President Trump's immigration order. Even in that term, after which Justice Kennedy retired, the justices agreed unanimously on the judgment almost 50% of the time. And interestingly, even when they were divided 5-4, not all of those 5-4 cases were left versus right, Democrat versus Republican. A quarter of them weren't. You had all kinds of interesting lineups and divisions. Right? The May Court, what I'm trying to say, does the work that I think was envisioned by those who framed the Constitution and ratified it. The May Court resolves legal disputes between states or between a state and the federal government. It deals with cases involving ambassadors and foreign governments and maritime jurisdiction and diversity jurisdiction. One of my favorite cases from when I was a law clerk was called United States versus Alaska. Alaska's my home state. I was the only clerk who was really rooting for Alaska to win that one. It involved ownership of submerged lands, and as you might imagine, it also involved ownership of the oil under those submerged lands in the Arctic Ocean. Unfortunately, Alaska lost, but my point is, this is the kind of case that the Supreme Court was set up to resolve, United States versus Alaska. The May Court settles disagreements among lower courts about the interpretation of federal statutes. So a few years ago, there was a wonderful case that I use in my criminal law class called Yates that involved the question whether a fish, a red grouper, counted as a, quote, tangible object within the meaning of the Sarbanes-Oxley Act. Justice Kagan's dissent notably included a citation to Dr. Seuss's one fish, two fish, red fish, blue fish, which I think was the first time that had been cited. But one of the things I really underscore for my students about this case, we read it to learn about statutory interpretation. It's a lot of fun. The majority is written by Justice Ginsburg, and Scalia is with her. The dissent, written by Justice Kagan, Thomas is with her. They disagree entirely about whether a fish is a tangible object. It's a 5-4 decision, but I don't recall it actually appearing much on the front pages or on All Things Considered. This year, the May Court has issued some fascinating opinions, like a unanimous opinion concluding that Alaska's Nation River is not public land and therefore is exempt under the Alaska National Interest Lands Conservation Act from Park Service rules. It's issued an 8-1 decision that, quote, when civil process is served on a foreign state under the Foreign Sovereign Immunities Act, a mailing must be sent directly to the foreign minister's office. And we're eagerly awaiting the May Court's ruling, of course it's not May anymore, in a case presenting the question whether punitive damages may be awarded to a Jones Act seaman in a personal injury suit alleging a breach of the duty to provide a seaworthy vessel. And there's all kinds of good May Court stuff still coming up. Next year, the May Court has agreed to decide whether under federal maritime law, a safe berth clause in a voyage charter contract is a guarantee of ship safety. Well, if you're still awake on a Saturday morning after hearing about the May Court, good for you. The May Court usually has 9 members, but not always. It hasn't always. Congress has fiddled with the number of justices over the years. Sometimes it's blocked the nominations of particular presidents. Seats have often gone vacant for months, even years. There was one seat eventually held by Justice Henry Baldwin that went empty in 1844 and was vacant for 841 days. As you probably know, the Constitution actually doesn't say how many justices the court is supposed to have. It might suggest that there has to be at least one, because it does refer to the Chief Justice. So it's interesting to imagine the court just dwindling down to one. That can make for some interesting oral arguments, I think. But even with the one, there's no mechanism that Congress could have to compel the president to nominate somebody or to compel the Senate to confirm it. The founders expected that the vast majority of the nation's judicial business would happen in state courts, and it does. I taught a course this year on state constitutional law. Notre Dame is one of the few law schools in the country that teaches the subject. It's fascinating, but think about it. We have 51 other constitutions, or rather we have 51 constitutions, 50 other ones, and students often don't learn about these. So what's my point of this comparison? What am I trying to get at? Well, in the preface of his book, the late Chief Justice wrote that whether or not the court is the least dangerous branch, it is surely the least understood. And I'm trying to suggest that in order to really understand the court as an institution, we have to appreciate the fact that the hot button 5-4 cases that you read about in June are not all that it does, and that the divisions that we're told about by journalists are not reflective of a lot of what the court actually does on a day-to-day basis. Right? I don't want to downplay the significance culturally, politically, morally of what the June Court does, but I do think that as citizens we can have a fair bit of confidence at a time when there's so much polarization and division, and at a time when some of the other branches of government might not seem to be working as efficiently as we'd like, that the court actually does work pretty well. In my view, we'd all be better off if more of us saw the court, and indeed if the justices saw themselves more like the May Court and less like the June Court. It seems to me that journalists, lawyers, and law professors need to do a better job of educating the public about the court as an institution. And perhaps all of us as citizens need to do a better job of consuming and filtering the information about the court that we get. It shouldn't have mattered so much last summer that a genial 81-year-old Republican lawyer from Sacramento retired. And it shouldn't have been the case that the prospect of his replacement by a 53-year-old Republican lawyer from Maryland triggered in some quarters existential crises, torrents of online hate, or was regarded by some as portending the coming of the zombie apocalypse. It shouldn't be that way. Well, some thoughts about the court, including the June Court, looking ahead. After all, that was the topic that I was given. In my view, one of the most significant political events that's happened in the last several years, both for the country and the court, was the death in February of 2016 of Justice Antonin Scalia. He was 80 years old. He had served as an Associate Justice for 30 years since his nomination by President Reagan, and his 98-0 confirmation vote that year. It's worth remembering that on the other side of the political spectrum, his good friend Justice Ginsburg also received 96 yes votes. Justice Neil Gorsuch, who was Scalia's replacement, had 54. Now, I'm not a political scientist, but I play one on TV sometimes. I've read, and it seems true to me, that for many people, the question of who would fill Justice Scalia's seat played a big role in their political decision-making in 2016. Certainly, it appears that for many people, this was one reason why they supported the candidacy of President Trump. As everybody knows, in 2016, President Obama had nominated Judge Merrick Garland, a respected federal judge, to fill the seat, but the Senate Judiciary Committee did not hold a hearing, did not hold a vote, did not bring the nomination to a vote, and it was eventually withdrawn. Well, one thing leads to another. As you probably recall, the Democrats sought unsuccessfully to filibuster President Trump's nominee, then Judge Gorsuch, who was eventually confirmed in the spring of 2017. And then the Republican majority in the Senate eliminated the filibuster for justices going forward. Justice Gorsuch is 1 year older than I am. He's 51, which means that if current patterns hold, he'll be on the Supreme Court for 30 years. Now, Justice Scalia's death and the vacancy that it created, it made a difference in several hot-button June Court cases last year. This is clear. And last year, in a number of cases, it made a difference that Justice Scalia's replacement was Judge Gorsuch instead of Judge Garland. I don't mean to deny that political reality. It's going to make a big difference this coming month, this coming June, that Justice Kavanaugh has replaced Justice Kennedy, and that President Trump is the one who nominated Justice Kennedy's replacement, and former Secretary Clinton did not. 2 of the current justices are over the age of 80, and it will certainly make a difference to the June Court who nominates and who confirms those justices' successors. But again, at the risk of being a broken record, it won't make that much of a difference to the work of the May Court. Well, we are entering, it's June, the fever swamp days for the Supreme Court news coverage. I have to keep, I'm not usually a coat and tie and suit sort of law professor, but I have to keep one in the office in case they want to run me over to the TV studio to do the talking head thing about the Supreme Court for the next couple weeks. Some of the cases that are coming down the pipe in the next few weeks that you might have heard about include cases about whether the administration lawfully added a question to the 2020 census about citizenship. There are some really interesting cases about administrative law and the power of administrative agencies to make and to interpret their own rules, and the power of Congress to delegate its legislative power to administrative agencies. That might not sound like such a hot topic, but believe me, it really is. After all, we don't get to vote for the people who make the rules in administrative agencies. And so a concern that's been a part of our national conversation for over 2 centuries is whether it makes sense for Congress, who is accountable to us, to be able to delegate the power to make rules to these administrators who are not. There's a case about whether a 90-year-old war memorial cross in Maryland is an unconstitutional establishment of religion. Some of the coverage about this cross case, interestingly, the headline says, "A war memorial shaped like a cross," which if I had hair, I'd pull it out because it's not shaped like a cross, it is a cross. That's kind of what things that are shaped like crosses are. One of the proposals for this cross to bring it into constitutional compliance was to chop off the arms, and then it would just be like a stick, and I guess that's constitutional. There are a couple big cases pending about the power to draw legislative districts, right? Claims about gerrymandering on political grounds, and also coming out of Virginia, a case alleging that the legislature drew lines on the basis of race. These cases are interesting, they're important, the justices will disagree, they will disagree on 5-4 party lines in some of these cases, but again, as you consume the news of these stories and as your social media feeds blow up with commentary and criticism, it's worth remembering that the calm days of December and January will come again and the court will once again be unanimous. Next year, the court will be hearing some cases that I think will also be of great interest and that will probably capture the attention of the June Court. One is whether federal law that prohibits discrimination on the basis of sex should be interpreted to also cover discrimination on the basis of sexual orientation or gender identity. Congress has so far not waded into changing the definition of sex in these non-discrimination laws, but some courts have interpreted the term sex to cover these additional categories on their own. The court will decide whether that's correct. The court has in front of it New York City's ban on transporting a licensed, locked, and unloaded handgun to a home or a shooting range outside the city limits. So no kind of border crossing in New York City with firearms. And the court will decide whether that's permissible under the Second Amendment. There's an interesting case coming out of Kansas about whether a state is permitted to abolish the insanity defense, or whether the Constitution requires states to offer that to criminal defendants. And no doubt there will be more. In particular, as I'm sure you know, everybody is glued to their screens waiting to see if the court will take up one of the new state laws involving regulations of abortion, especially earlier term abortions, the heartbeat laws that have passed in some states. There's a great deal of speculation, and it's not just speculation, it's quite reasonable, that the current composition of the court might take a different view of regulations of abortion than the court had in recent years. And of course, this has heightened the stakes and heightened the controversy surrounding the court's membership and any potential retirements. Well, what about the future of the court as an institution? Most observers believe that the judicial confirmation process is broken. They put the blame in different places. You know, was it the fault of one party? Was it the fault of the other? Did it start with Judge Bork? Did it start earlier? I'm not here to referee those debates, but it does appear that we are not going to see any 98-0 confirmations of Supreme Court justices anytime soon. It appears instead that it will be the new normal for senators to simply refuse to support nominees when the president is from the other party. Indeed, it could be that we simply won't see seats being filled when the president and the Senate are of different parties. I feel like in much of the commentary that I see, there's a bit of an exaggerated hand-wringing about this fact. My own view is that if you step back and look at US history, it's always been the case that the process of nominations and confirmations has been politicized in various ways at various times. It mattered a whole lot to the Republicans after the Civil War that they could get justices on the Supreme Court who were willing to uphold the constitutionality of paper money. It mattered a whole lot when President Lincoln was running for the Senate, what senators thought about the stare decisis value of cases involving race discrimination, including the famous Dred Scott case. So we can take some comfort perhaps in the fact that even though we're divided right now over the role of the court and its membership, this is not unprecedented. At the same time, the law professor in me who likes to tell students that law is not just politics, that a Supreme Court decision can't be predicted simply by asking what a justice had for breakfast or for whom he or she voted. And as somebody who had the experience of watching the justices, including justices from very different parties, doing their work as conscientious, skilled, technically sound lawyers, part of me does have perhaps this naive wish that we could see a day of 98-0 confirmations again. But Justice Scalia used to remind people when he would give speeches in law schools and in the public that it was a mistake to ever imagine that people weren't going to care a lot about who sat on the Supreme Court once the Supreme Court started making decisions that people really care about. As he would put it, if the Supreme Court decides that it's the Supreme Court's job to resolve our divisive, controversial questions over religion, church-state relations, abortion regulation, racial discrimination, once the court says we're the body that's going to make those decisions, well, of course people in a democracy are going to care who's on the court. Of course candidates are going to run and talk about the Supreme Court and who they might nominate. This shouldn't be surprising. Scalia's suggestion, and I have to admit it rings true to me too, is that one way to heal the judicial confirmation process and to dial down the heat that surrounds that process is actually for the court to recede a little bit, to do a little less, to be a little more humble, to leave some issues to politics. And it does seem like the current Chief Justice, in some cases anyway, is looking to do things like that, is looking to find ways to keep issues in the political arena rather than taking them up into the court. What are some other things that might help? At the risk of sounding really heretical, and I realize how difficult it is to amend the Constitution, I don't think the answer is, as some candidates have suggested, to increase the size of the court to 15 or to change who it is that gets to nominate the judges. But I do think the Constitution should either be interpreted or amended as allowing Congress to put term limits on the justices' years of service. It was very important to the founding generation that we had an independent judiciary, and that's very important to me that we have an independent judiciary. So Congress isn't allowed to reduce the justices' salary as punishment for decisions they don't like. That's valuable. But it seems to me that an independent judiciary wouldn't be threatened by a rule that said something like terms on the Supreme Court are 18 years. Right? That's a pretty long time. It shouldn't be the case that we're all watching carefully to see when Justice Kennedy is going to retire or if Justice Ginsburg is going to retire. It shouldn't matter so much that a retirement happens during one presidential administration rather than another, or that it happens 6 months from an election rather than 18 months. It seems to me that we could dial down some of the heat if we were to have some kind of regulation of judicial terms. But again, I'm afraid we probably would have to amend the Constitution to do that. Again, some have suggested increasing the court size. Of course, we might also say we could decrease the court size. A number of political scientists have said that a court that had 8 members instead of 9 would actually agree more often. It's an even number. You can't have a 5-4 split, right? And we saw some of that actually when Justice Scalia's seat was vacant. There were a number of cases that might otherwise have been 5-4 that ended up being 8-0 because the court just found a way to make the case go away. Another related proposal is to have just staggered terms, right? So every president would know that he or she was going to get a Supreme Court nomination every 2 years. Again, that might reduce the stress that comes from wondering whether so-and-so is going to retire or so-and-so is going to leave the bench. And perhaps you have some other ideas. But in any event, notwithstanding what some candidates on the trail are saying, I want to leave you with what I started saying, and that is that in my experience, not only as a clerk and not only as a lawyer, but also as a teacher, the Supreme Court, at least for 11 months of the year, runs efficiently, well, and collegially, and Congress and the executive branch could do well to emulate their example. What about the Jun Court? Well, the problems that I see with the Jun Court, it's overreaching, it's hubris, it's outsized role in our society. That's not entirely the justice's fault. That's our fault too. We Americans have made a habit of asking the court to take care of the things we disagree about rather than trying to convince each other. So I guess I'll just leave you with 2 cheers for the court, that is, the May Court. And with that, I'll stop and I'll take any questions you have for as long as you want. Yes, sir. Yeah.
I read an article that said that it may be unlikely that the Supreme Court would take up some of these abortion cases because there won't be any split in the circuit. Mm-hmm. And that basically what they'll end up doing is kind of work around the edges to change the abortion. What do you think of that argument?
Yeah, I think that's a plausible prediction. Let me give a little background. One of the things the Supreme Court does is it sits back and waits for the lower courts to disagree. And if the lower courts don't disagree, the Supreme Court often doesn't feel the need to swoop in and say, hey, we agree too, right? So if the federal XYZ Act, provision 123, involves an interpretation of the word fish, and everybody agrees on what a fish is, the Supreme Court often won't take that case, right? One way to say it is the Supreme Court often doesn't grant cert to agree. It grants cert to resolve disagreements or to disagree. And so, as the gentleman said, since some of these abortion laws that are being passed in some of the states are going to be struck down by lower federal courts under the Supreme Court's existing precedent, it's very possible that there won't be any disagreement among the lower federal courts. They'll all just strike down these the heartbeat law cases or the early term bans. Indiana, as you might know, had a rule that prohibited abortions that were done for the purpose of sex selection or singling out unborn children with disabilities. That was struck down by the Seventh Circuit, and the Supreme Court didn't take the case. So, as the gentleman asked, will the Supreme Court actually not have to take any of these cases? My own view is that the court needs to take one of these cases because, as I see it, even if there isn't a disagreement among the federal courts, in a system like ours where we still have state governments and we still have state constitutions and we still have some measure of state sovereignty, it's limited obviously, the people of a state, right, whether it's New York with a very permissive abortion law or whether it's Indiana or Alabama with a more restrictive abortion law, the people of those states and the legislatures of those states, they have a right, in my opinion, if their work is struck down by a lower federal court, they should have the right to have that decision reviewed by the highest court in the land, right? As I see it, the lawmaking activity of state legislatures is presumptively constitutional. And for a federal court to block a state law from going into effect is to limit the political power of the people of that state. So I think the prediction of the article you read is likely to be the case, at least for a while, in part because I don't think the justices are really eager to take one of these cases, especially in the run-up to an election. But again, given the way that I think our federal structure is supposed to work, I don't think the people of one state who've enacted one of these laws should have to kind of sit back and wait for some other court to disagree. Yes, sir.
In the case of, in the May term, the Supreme Court, in the case of Franchise Tax Board of California versus Hyatt, basically made a statement, because it was overruling an existing Supreme Court precedent in reaching its decision, made a statement on stare decisis, which seems to me essentially to effectively not eviscerate, but basically make it easier for the court to reverse precedent, which essentially, if, for example, the abortion decision gets before the court. And at that time, when it was decided, there was a lot of criticism of that decision as not being substantially constitutionally grounded. And under this recent statement by the Supreme Court, in this case, stare decisis, on stare decisis, I think basically, in effect, the Supreme Court could very easily overrule Roe versus Wade.
Yeah.
What is your opinion?
So let me invite, first of all, those of you who are standing, please feel free to come sit. But if this gets too boring, I want somebody to throw something at me, all right? Because I'm going to get a little bit, I have to get in the weeds a little bit to answer this question well. So as people in this room probably know, stare decisis is a cool lawyer buzzword for the idea that past decisions shouldn't be lightly overruled. That even if a judge in 2019 comes to think that a past decision was incorrect, that they shouldn't just throw it out the window without a good reason. Right? The principle of stare decisis is important. It helps to preserve stability in the law. In cases involving statutory interpretation, it strikes me as a particularly good rule of thumb. You don't want the rules changing all the time, you know. And after all, Congress can always step in and change a statute if it wants to. People disagree, though, about how strong this rule, how strong this principle should be in cases involving constitutional interpretation. I mean, if the Supreme Court gets the Constitution wrong, then why should that wrong decision continue to have any claim on people going forward? Any claim on future justices? I mean, if the Constitution is supposed to be the product of we the people, and the justices misinterpret that, why can't we the people get it fixed? It's a powerful debate, right? At the same time, the court has told us many times that even in constitutional cases, this principle of stare decisis is supposed to have some weight. That just because a current majority of 5 disagrees with a past majority of 5, the court shouldn't just flip, right? And again, there seems to be something to me that makes sense about that, but I'm not totally convinced. Now, the case that the gentleman mentioned this term involved a mind-numbing legal doctrine called sovereign immunity. And sovereign immunity basically involves the ability of state governments, to be sued in court, right? Whether it's the court of another state, the court of the national government, or indeed its own courts, right? It's an ancient idea. The sovereign is immune from certain kinds of lawsuits. Over the years, since the mid-90s, and this was largely under the influence of Chief Justice Rehnquist, the court's doctrine on stare decisis evolved. It became more friendly to state sovereignty. The court, over the decades, in case after case after case, strengthened the principle of sovereign immunity. So we got to a point this year where there was this one precedent that was sort of sitting out there, kind of like a boat on the ocean with no wind and going nowhere. It was an outlier. It was like the doctrine that got left behind, you know. And so in this case that was decided this term called Hyatt, a 5-justice majority of the 5 Republican nominees, they said, look, given what's been happening for the last 20 years, this case is an outlier. We're going to overrule it, right? Now, that's actually not as dramatic a thing as some of the press coverage suggested. That is one of the traditional reasons that justices give for overruling a past case is, has it become an outlier, right? It might have, the law evolves in some areas, and if this is kind of the last outlier rule standing, then we can overrule it. So that's what the 5-justice majority said in this Hyatt case. We're overruling that. The dissenters, though, I think they saw a dynamic like the questioner did, which is that, these justices are willing to overrule precedents, even ones that are 40 years old. And we're thinking of another precedent that's around 40 years old called Roe versus Wade, and maybe that they're signaling they're going to reverse that too. It's a possibility. But I would caution against overreading that. I mean, a week after that case, a different 5-justice majority, this time headed up by the more quote-unquote liberal justices, they also reversed a 100-and-something-year-old precedent having to do with the treaty rights of a particular Native American tribe. I'm not a cynic about the court, as I hope I've managed to communicate, but I will say that a lot of people believe that this principle of stare decisis is invoked inconsistently and maybe opportunistically by justices from time to time. That when they want to overrule a decision, they do, and if they don't want to, they don't. So it seems to me that the question whether the court will change its abortion jurisprudence, whether it will allow states more room to regulate, right? Whether it will say, look, we were wrong in Casey, we were wrong in Roe, we're going to just give this back to the states, and New York will do one thing and Alabama will do another. Who knows? But I think that whether or not they do that is not really going to be determined by this principle of stare decisis. I think it's going to be determined by what a majority of the justices think the Constitution actually means. And that's why it'll be controversial, because if the court were to permit greater regulations of abortion, it would certainly be framed in the press, I think, as this very dramatic, revolutionary thing. But as you're seeing in Illinois, New York, Virginia, Vermont, the states retain the ability, if they want to have very permissive abortion regimes. So even if Roe and Casey were overturned, even if stare decisis didn't prevent it, you would still have a great deal of legislative activity on this issue, and which way that activity cut is above my pay grade. Yes, sir?
Yes, okay. Good morning. With regard to this question on citizenship that's going to come up in the next week or couple weeks, what is your specific opinion about how the court's going to go based on the wording in the Constitution as to what the government's supposed to do as to count people or count citizens, or what's the requirement? What do you think is going to happen?
Yeah, I remember I said at the very beginning that my ability to predict has been famously compromised and negated. So I predict that the court's going to say that the administration had the legal right to add the question about citizenship. The Constitution doesn't prevent such a term, and it had been used in the past. The concern, as it sounds like you know, is that by adding a question about citizenship, and the census is supposed to count people, not just citizens, but adding a question about citizenship will cause some people to not cooperate with the census, which will disrupt the count, which will work to the disadvantage of some states, right? I don't think that concern is frivolous. It just strikes me that the justices are not going to want to be in the position of them being the ones who decide this particular question. I think they're going to want to regard this kind of like I predict they're going to deal with the political gerrymandering cases as a matter that they'd rather leave to the political process to fix, right? Another reason why I think this is the case is that the people who are challenging the use of the citizenship question, a lot of their argument rests on claims about the motives of the officials who were adding the question, right? So it's not so much that they're saying you can never have a question about citizenship. The challengers are saying something like, look, we don't trust this administration's reasons for adding that question about citizenship. And my sense of the current court, we saw this in the decision last year about the immigration executive order. The current justices, at least a majority of them, they're nervous about legal arguments that basically invite the court to speculate about the motives, the bad motives, of people in the coordinate branches, right? I'm actually sympathetic with that concern. I think to the extent we can, we shouldn't have constitutional rules depending on what we think the motives of certain actors were. It shouldn't be the case that the question is okay if one administration does it, but it'd be bad if a different administration did it. Now, I don't have a strong view on whether the question makes sense. I do think it's important to remember, I think at least a lot of my students don't know this, that the census is a constitutionally mandated thing that the government has to do, and it is supposed to get a count of everybody, not just citizens. So I understand the concern that the citizenship question might disrupt the count, but again, I think that's a concern that has to be worked out in the political process, probably not in the court. I hope that's responsive to the, yes ma'am?
I have a question about something you said, and I want to make sure I got it right. If the Supreme Court gets a constitutional decision wrong, we should get to change that as a democracy?
Sorry, I didn't hear you.
Oh, did you say that as a democracy, we should get to change that? Like that stare decisis shouldn't?
I don't think it should be. I don't think that stare decisis should be in sort of absolute and kind of immovable obstacle to returning the court's doctrine to what we think the correct doctrine was. Now, obviously, the ability of the people to do it, and I should have been more clear on this, is tricky. We can do it through constitutional amendment, but that's really hard, right? Or we can do it in this kind of indirect way where this is what happened in the presidential election of 68 and 72, I believe, is that the people elected President Nixon because they wanted President Nixon to give justices who would modify some of the criminal procedure rules that the Warren Court had been developing. And so that was a way that the political process was able to work an evolution in judicial doctrine.
Here's my question then. I know some people think that in the instance of this court, some people, the concerns about whether Roe v. Wade would be overturned, and if that hinged on one vote by a justice who was confirmed by, was it 54 votes?
50.
50 votes. What are your thoughts on that?
Yeah, well, so let me preface this by saying that that particular question, which is really a question of political morality and so on, is one that none of you should think a law professor has any particular expertise in, right? So you shouldn't. I know I'm the atypical law professor in not thinking that my opinion is really the gospel. I'm not particularly. Well, let me give classic law professor thing, a two-part answer. On the one hand, yes, of course, the optics in the political process would be bad, right? It's always bad when a 5-4 court overrules a precedent, right? And given the controversy that has surrounded the nominations process in recent years, and it's been getting worse and worse, and given that so much of that conflict has focused on this issue, yeah, as a citizen, I would sort of regret all of the bad feeling that would create. At the same time, as a citizen, and again, none of you have to agree with me on this, but who thinks that Roe and Casey were wrongly decided, I'd rather live under a constitution that was interpreted correctly than incorrectly. And so for me, the fact that those decisions, that a decision modifying Casey and Roe would be 5-4, I'd prefer for it to be 9-0 for sure. That's not a reason to not correct the error in my view. Now again, as I hope I said earlier, I do think that stare decisis is worth treating pretty strictly in cases involving the interpretation of statutes. But at least in my view, when you're getting to a case that Americans were divided on from the day the case came down, and that division has not eased. Other controversial cases, the controversy has kind of worked itself pure. People aren't marching in the streets every year about the Miranda decision or about the school prayer decisions, but they're marching in the streets every year about this decision. And I think that's a signal that the court overreached. And to undo that overreach wouldn't definitively answer the question of how abortion should be regulated, but it would make it something that would have to be taken care of in politics. Now that would make politics kind of messy. I mean, you might think it's kind of nice to actually have that out of politics and with the justices. I'm enough of a small d Democrat to think that the more important a question is, the more it belongs in politics, and not the less it belongs in politics. So I'm sorry if I misstated in my initial answer, if I caused some confusion.
Kind of seeing where your limits were placed.
Yeah. Yeah, fair enough. I got a bunch. Let's go over here. Yes, sir.
It sounds like you think that the gerrymandering cases are going to be decided as political questions.
Yeah.
Is there a workable solution? And I'm not talking about the racial gerrymandering, which I think is probably a little bit easier. But is there a workable solution where you're developing districts based on voting patterns and the argument that people that are packed into one district are effectively disenfranchised?
So there are, I'm glad you raised both of those. It seems to me that the constitutional warrant for the court supervising racial gerrymandering is a lot stronger, right? And then add to that the Voting Rights Act and the 15th Amendment and all that. There are still sometimes difficulties, and I do worry about this game of sort of presuming bad motives on the part of people who are drawing lines in certain ways. But I think on the racial gerrymandering, I don't know what the right answer in that particular case is, but I'm inclined to think the court can decide cases like that. Partisan gerrymandering strikes me as a different thing. politics is partisan. And if a court wants to avoid the appearance of being excessively involved in political questions, this seems like something they should be really nervous about getting into. Now, it sounds like you know that there are some social scientists who claim to have developed methods and models that will actually, that could be judicially enforceable tools that would enable them to identify, in accord with the premises of their model, what counts as a gerrymander and what doesn't. I don't know, though, where in the Constitution is the basis for any objection to the partisan composition of a particular district. I know that some of the arguments, Justice Kennedy seemed to like these arguments, that it violated your First Amendment right of association if you were packed into one district because you couldn't associate with people of another party in another district. That's creative. I'm a law professor. I like creative arguments, but I don't think it's plausible, right? I mean, that's the freedom of association and the freedom of speech. It doesn't seem to me to be implicated by this. I think there are things that states can do on their own, either under their state constitutions or just under state law, to set up, independent commissions and so on to structure at least they can structure their state districts in ways that they like. It's not obvious to me that state commissions should be able to interfere with the shape of congressional districts, because I think the Constitution says that's got to be done by the legislatures themselves, but I think the court disagrees with me on that. So just circling back, my prediction is, notwithstanding these new models, and you're right to raise them, and notwithstanding the case that's been made that, hey, the worry that you used to have that courts wouldn't have any standards, here are some standards they can use. I think the majority of the court is still going to want to stay away from that issue.
Will that be kind of like a 8-1, 9-0 type thing, or do you think it'll be a split?
Well, it's interesting. They had a chance to do this earlier, right? And I think that at least 4 of them signaled they were pretty open to allowing judicial review of these kind of things. So my guess is if the court finally, after 20 years of kind of dancing around, just says definitively, these are non-justiciable political questions, that you'll get 4 justices dissenting from that. But again, my predictions of... I think, by the way, just so we're clear, here's a prediction I feel pretty good about. I predict that the Supreme Court is not going to say that the cross has to have the arms chopped off in Maryland. I just... call me crazy on that. Yes, sir.
Staying on that gerrymandering thing, I'm from Pennsylvania, and we had our congressional districts struck down by the Pennsylvania Supreme Court, who then gave the Republicans 2 weeks to come up with a new plan and get it approved by a Democratic governor, or they would set up their own districts, which of course is what they did. And my understanding is kind of the reverse happened in Maryland. And it seems to me that some guidelines from the Supreme Court are going to have to be established for this gerrymandering. Either let it go completely, or some standards that they use for setting up these congressional districts.
So I'm glad you raised both the Maryland and the Pennsylvania examples. They're 2 more data points that we might want to use. I don't want to sound obstinate, but I guess I am just going to kind of dig in and say that, notwithstanding the messiness of the process you describe, and if I lived in Pennsylvania or Maryland, I'd find it kind of irritating, especially if I was a legislator. It strikes me that our Constitution doesn't guarantee that we're going to be unburdened by messy politics sometimes. And all things considered, think of all the cliches. Don't let the perfect be the enemy of the good. This side of heaven, settle for the second best, and all that. All things considered, I would prefer a regime where the shape of legislative districts were determined politically rather than through judicial review, outside of the race context where I think we have a specific constitutional mandate to eradicate race discrimination in voting. Yes, ma'am.
I have a question regarding the Second Amendment, our Second Amendment rights, so-called. And I don't know an answer. I'm from Texas, so you could.
When I was a kid in Alaska, we used to joke that if Texans didn't start showing a better attitude, we were going to chop our state in half and make Texas the 3rd biggest state.
It's kind of a twofold thing. One, how do you see this area progressing? One thing that surprised me is, and I'm not an attorney, I don't know much about the Constitution, but I hear these terms, textualist and originalist, and they're separated, and I hear so much interpretation regarding this well-regulated
Yep.
militia.
Yep.
And of course, this is an ongoing debate in our country. So where do you think the court is going on this, and how will these so-called concepts of textualist interpretation and originalist interpretation, and then of course more liberal interpretation play in?
Well, that's a great question. So the first day of my constitutional law class, what I used to do was I would give all the students the text of the Second Amendment, some stuff from Blackstone, some stuff from some early state decisions, some stuff from state constitutions at the time, which had to do with firearms, early British cases about the right to have firearms, which was a very well-established right for Protestants, but not Catholics. Give them some cases, blah, blah, blah. And then, first day of con law, how do you go about interpreting this text, right? Here's I've got the text of the Second Amendment in here somewhere, but how do we decide what this means? And it's a great way to start. You have the students say, well, you look to precedents, or look to dictionaries from the late 18th century, or look to the philosophers that Thomas Jefferson might have been reading, and so on, right? You're right, this is a debate that goes on and on. Some of us think that you got to stay pretty closely tethered to the constitutional text, because after all, that's the law that was enacted. Others say, no, the Constitution, especially its broader terms, should be interpreted in a pretty broad way, in keeping with contemporary values and changing norms and so on. So there's this debate. One of the things about the Second Amendment that's so fascinating is that for the most of our country's history, there was no law interpreting it, right? People sometimes forget, actually, there was no law interpreting the First Amendment either for the first 130 years of our nation's history. But the Second Amendment got even more delayed in terms of actually getting a judicial determination of what it meant. And the first couple times the Supreme Court considered it, very unreasoned, off the cuff. It was. I think the first case had to do with a submachine gun. Like, think of those gangster movies from the 30s, and they banned those. What happened over time was that scholars, and it wasn't just on the political right, scholars started digging into the understanding of the right to keep and bear arms in the late 18th century, both in England and the US. And they came to the conclusion that the court had probably been too quick to say, oh, that's just about the National Guard. There came to be a view that actually the Second Amendment was about, at least in part, the ancient individual right of self-defense, right, which Blackstone had talked about. So this gets developed, and it percolates, and it works its way through courts. And one of the federal courts of appeals, I believe it was the Fifth Circuit, sort of finally took this individual rights theory seriously and gave the Supreme Court a chance to visit it. And so in this case called Heller, which you might know about from a couple of years ago, and then again in a case called McDonald, the court said 5-4, the Second Amendment isn't just about the National Guard. It does protect an individual right to own a gun that's deeply rooted, goes all the way back to the 18th century. The founders cared about it a lot. The framers of the 14th Amendment cared about it a lot too, because one of the first things that the Republicans in the 1860s were worried about was that the freedmen in the South were going to lack the means to defend themselves because they were going to be disarmed from Southern legislatures. In any event, we're now in a position in 2019 or whatever, where we don't have all this judicial doctrine to use to decide whether particular local gun regulations are constitutional or not. The court's been cooking up tests and doctrines in the free speech context for 70 years, right? I got all kinds of stuff I can teach in my First Amendment class. If I had a Second Amendment class, it'd be like day one and then we're done. There's not much there. The students might like that. The exam would be straightforward, but we don't have a lot of law. So with the Second Amendment right now, we have this kind of interesting natural experiment where the modern court, now that we've been told there is an individual right, the court has to decide, okay, what tests are we going to use to decide how far that right goes? When may it be limited? Because it may be limited, just like your free speech rights may be limited sometimes. What kinds of government interests will outweigh the right to own a gun? What counts as an arm, a howitzer or whatever? So for me, and I don't have sort of strong personal commitments on this issue, but just in terms of constitutional law, I think it's actually a fascinating thing that the Supreme Court kind of woke from the dead this individual right in the 2000s, and now we get to observe it trying to decide the implications of that right. And my prediction is it's going to be kind of like the Fourth Amendment right to be free from unreasonable searches or the First Amendment right to have freedom of speech, that we'll see courts developing these balancing tests where, presumptively a law-abiding person has a right to keep and bear firearms in this country. And that's not going to change unless we amend the Constitution. Some people would like to amend the Constitution, that's fine. At the same time, I think courts will uphold what they regard as reasonable limits on that right? So perhaps for people who've been convicted of violent felonies, sometimes people suggest that people with certain psychological difficulties or history shouldn't be allowed to keep and bear arms, but that's a little tricky when you start taking away people's rights because they went to see a counselor one time, So it's to be determined, right? But I don't predict the right to keep and bear arms in America will go away. It's too deeply rooted culturally, it seems to me. I'm giving the hook. So have fun at your reunion, and thanks for coming in the morning.